Hi everyone, welcome to this session on international arbitration. Today we're going to look at the doctrine of sovereign immunity or state immunity. In an arbitration, a state entity may rely upon the doctrine of sovereign immunity to claim immunity from 1. The enforcement of the arbitration agreement. It can do this directly, that is, it may refuse to submit to the jurisdiction of the tribunal, or it can do it indirectly by refusing to submit to the jurisdiction of the courts looking to enforce the arbitration agreement. Even if it submits to the jurisdiction of an arbitral tribunal, its immunity will kick in with respect to any judicial proceedings commenced in aid of the arbitration, for example, interim orders, in the appointment of arbitrator, etc. 3. And most importantly, once the award is passed, states can claim immunity against judicial proceedings to enforce the award against it. This raises the question of what you can do when you're arbitrating with a state entity. First, the general rule is that a state's immunity from suits and arbitral proceedings can be waived. That is, a state can consent to participate in the relevant proceedings. Parties can insert some standard form waiver language into their arbitration clauses in this regard. It is generally recommended that the waiver language be as broad in scope as possible, covering the state and all the assets of the state that you may need to proceed against at any point in your dispute. You should ensure that the state submits to the jurisdiction of the tribunal and to the courts with support of jurisdiction. You should also ensure that this submission to jurisdiction is complete. That is, there are no particular types of relief that cannot be ordered against the state. Most importantly, you should ensure that you can file court proceedings against the state to enforce or execute the arbitral award. You should ensure that you can proceed against any assets or revenues of the state that you may need to ensure successful execution. A waiver of this nature is generally wide enough to cover 1. The state's submission to the agreed arbitral proceedings, 2. To the supervisory courts of the seat, and 3. To the jurisdiction of the courts of enforcement. The English case of NML versus Argentina considered the issue of whether an express waiver of Argentina's state immunity in certain bonds issued by it, the relevant waiver is shown on screen, was sufficient to enforce a New York judgment in England. The court unequivocally held that it was. The general rule to remember with respect to express waivers, to ensure that they are applicable in most jurisdictions, is to be as specific and clear as possible. A recent French decision also highlights why waivers may need to specifically mention the assets or categories of assets to which they apply. Now, what if you entered into an arbitration agreement with a state entity, but you've not included this type of express waiver in your arbitration clause? Many jurisdictions, including UK, Singapore, South Africa, and Pakistan, have enacted legislation that say that agreeing to arbitration constitutes an implicit waiver of immunity, not just with respect to the arbitral proceedings, but also with respect to the supervisory courts at the seat of arbitration. For example, the UK State Immunity Act of 1978, which regulates immunity of a foreign state in the UK, provides that an arbitration agreement, subject to contrary provisions in the agreement, disentitles the foreign state to jurisdictional immunity. However, this may not extend to immunity from enforcement. For example, in a recent Hong Kong case, it was suggested that such immunity could only be conferred by legislation or by an express representation by a foreign state to the foreign state. India does not have a separate statute on state immunity. The doctrine of state immunity, as well as the exceptions to the same, are dealt with in Section 86 of the CPC. Section 86 subclause 1 stipulates that a foreign state cannot be sued in India without the consent of the central government. It also directs the central government not to accord its consent unless it appears to the central government that one of the conditions in subclause 2 are satisfied. Condition D in subclause 2 provides that the central government's consent to waive immunity may be given if the foreign state has expressly or implicitly waived its privilege. Unfortunately, the CPC neither defines nor explains these key phrases, nor does it provide any guidance for their determination. It therefore does not explicitly delve into the question of whether an agreement to arbitrate per se amounts to submission to the jurisdiction of courts in India or whether you need an express waiver in this regard. That's that on waivers. Let's now look at two other ways in which a party might be able to avoid the application of the doctrine of state immunity. The first is through something called the restrictive approach to state immunity. Under the restrictive approach, a sovereign state is not immune in respect of jurisdiction of the courts for its commercial activities. In England, this is statutorily expressed in Section 3, Subclause 1 of the State Immunity Act. It was on the basis of this Section 3(1)(a) that in the NML versus Argentina case, the Court of Appeal refused to uphold Argentina's immunity with respect to what it owed its bondholders, as these were proceedings relating to a commercial transaction. If you look at Section 86 of the CPC, Condition B of Subclause 2 also seems to relate to this concept, that immunity does not extend to commercial activities of the state. In a recent Bombay High Court case involving Qatar Airways, the court decided that sovereign immunity did not apply to commercial activities of the state and that accordingly, the central government's consent was not required. However, the statutory basis of this decision was not made clear in that case. Also, Section 86, unlike Section 3(1) of the State Immunity Act, does not contain a commercial activities exception. Subclause 2 only lists the conditions under which the central government may give consent. This case also discussed the third route under which a party may escape sovereign immunity, namely by arguing that the relevant state entity is not really a state or sovereign. This is usually a fact-based issue of what the degree of control or ownership that the sovereign has over the relevant state entity. In Qatar Airways, the court stated that since the airlines was a company with a separate legal personality, it could not amount to a state. It did not delve into the ownership structure or management control at all. However, there is an earlier Delhi High Court case involving the Saudi Arabian Airlines where the court did examine its ownership structure to conclude that it was a foreign state for the purpose of Section 86. That concludes our discussion of how the doctrine of sovereign immunity impacts international arbitration. Thank you for watching.